I beg pardon to make a mention, Miller. Last Friday, Lordship was pleased to direct matter list this matter today, Miller, but it has not come. Matter is related to criminal appeal more than 10 years, Miller. Appellant settlement cost.
There is
Lordship
no time
specifically
now.
directed list today, Miller, but it has not come.
Move after vacation now.
But tomorrow, Your Lordship.
No, tomorrow is the last working day. So many matters are likely to come in the single bench also. Tired of matters here. So
So let it come tomorrow.
we just give it is possible. We'll see. Give it.
Oblige.
May I please the Lordship? Mentioning for CRLA 644 by 2015, the appellant is in jail custody for about more than 12 years.
All I do give it is possible. It will be listed tomorrow.
And Lordship, there is another mention for JCRL 93 2017. The appellant is more than 10 years in jail custody.
Give it.
Lordship has directed for today custody certificate called for, and he's in custody today for fixed for
What is the period?
period above 9 years.
We will see that.
Weekly list item number 5.
See 5 now. This is the last order dated.
So appear.
Where is that order? Has not been done on 17/5 report. ତୋର ନାଁ କଣ? କିଏ ଆପଣ ମାନେ କିଏ ନାଁ କୁହନ୍ତୁ?
ମୋହନ ମୁଣ୍ଡା ଆଜ୍ଞା।
आपने ना कौन कहले?
ମୋହନ ମୁଣ୍ଡା ଆଜ୍ଞା।
मोहन मुंडा।
अच्छा
आपने
ନାଇଁ ମୋହନ ତ
आपने तो रहता
ପ୍ଲାନ ନମ୍ବର 4
फोर
ପାତଲୁ ତମ ଡାକ ନା ପାତଲୁ କି?
ନାଇଁ ଆଜ୍ଞା ମୋହନ ମୁଣ୍ଡା।
ସେଦିନ ମୋହନ
ଲାଷ୍ଟ ଟାଇମ କିଏ ଆସିଥିଲା? ମୋହନ ମୋଟା ତ ଥିଲା ନା
ସେଦିନ ଥିଲା କହିଲା
ତମ ପୁରା ଗତ ଥର ଥିଲ?
ନା ସିଏ ନ
ନାଇଁ ଆଜ୍ଞା।
ଆଉ ଗୋଟେ ଲୋକ ଥିଲା ସେ କଥା ମୋହନ ମୁଣ୍ଡା ତ ସିଏ ବି କହିଲା
ସିଏ ବି ସେ ଲୋକଟା ବି କହିଲା ଯେ ମୋହନ ମୁଣ୍ଡା ବୋଲି।
ହଁ
ମୋହନ ହରଣ ମୁଣ୍ଡା
ସାର୍ ସିଏ ମୋହନ ମହାରଣା ହେଇଛି।
मोहन महाराणा हाइट पिरोल 4 पिरोल 4 सेटा था
तो ही अपना नंबर 4 था
आगे
4 एंड अच्छा कल देखिएगा दो on 17/5/2024 appellant number 4 Patlu alias Mohan Maharana appeared to virtual mode from civil court complex Champua as per the order dated 15/5/2024. Inadvertently in the said order it is mentioned that appellant number 3 Mohan Munda appeared. Therefore, in the order dated 17/5/2024, in case of appellant number 3 Mohan Munda, the same shall be read as appellant number 4 Patlu alias Mohan Maharana. Putlu alias Mohan Maharana. Stop. ଆଜି ତାହେଲେ ମୋହନ ମୁଣ୍ଡା ତମେ ଅଛ, ଆଉ କିଏ ଜଣେ ଅଛନ୍ତି?
ଏମ୍ର ମୁଣ୍ଡା
ଆଉଥରେ କୁହ।
ଏନ୍ଦ୍ର ମୁଣ୍ଡା
ଇନ୍ଦ୍ର ମୁଣ୍ଡା।
As per the said order dated swan, so appellant number 3 Mohan Munda, appellant number 1 rather, appellant number 1 Indra Munda, and appellant number 3 Mohan Munda appeared through virtual mode. That a court so is a civil
Champua.
from civil court complex Champua. ଡାକେଇବାର ଉଦ୍ଦେଶ୍ୟ ଥିଲା ଯେ ବର୍ତ୍ତମାନ କେସ୍ ବିଚାର ପାଇଁ ରେଡି ହେଇଗଲାଣି, ତ ଆପଣ ମାନେ ନିଜ ଯୋଉ ଓକିଲ ଦେବେ ନା ଲିଗାଲ ଏଡ୍ ତରଫରୁ ଆପଣଙ୍କୁ ଓକିଲ ଦିଆ ହବ, ଯୋଉଥିପାଇଁ ଆପଣଙ୍କୁ କିଛି ପଇସା ପତ୍ର ଖର୍ଚ୍ଚ କରିବାକୁ ପଡିବ ନାହିଁ?
ସାର୍ ଆଜ୍ଞା ଆମେ ପାରିବୁନି ତ ତମର ଦେଇଦେ ତ
ଇଏ କଣ ଇନ୍ଦ୍ରା ମୁଣ୍ଡା ତମେ କଣ କହୁଛ?
ତମର ଆଣିକି ଦେଇବ
କଣ କହୁଛ?
ଆପଣ କରିବ ଆଜ୍ଞା।
ଆପଣ both the appellant number 1 and appellant number 3 on query submitted that they have no financial capacity to engage any advocate on their own, and a counsel from Orissa High Court legal aid panel be engaged for them. The statement made by the appellant number 4 and 5 on 17/5/2020 and appellants number 1 and 3 today. So and so is engaged as the exam producer. ठीक अच्छे आमे हाईकोर्ट रो आपन को वकील जोगी दिया जीवो हला ठीक अच्छे
ଆଜ୍ଞା
पिला केते नंबर
Item 6.
मेंशन करथिले ना नांती पासवर्ड नेक्स्ट
Item 7.
May I please your lordship? My lord, this matter was earlier listed, but due to some problem I have not appeared, and today I'm ready for hearing your.
Please use the mic properly. So as it appears there are 5 appellants.
My lord, I'm for the 1, 2, and 3, your lordship. If they engage it,
No, just but this interim application which is in the they are in the cause list, it shows that this IA number 1192 of 2023 has been filed for only 2 of the appellants.
yes, your lordship. I'm for the opposite appellant number 1 and 2 and 3, and 3 was already been released.
Released on bail, all right.
And subsequent application for 1 and 2.
Achha, this appellant number 1 and 2, whether their bail application was earlier rejected?
Yes, your lordship.
On what date?
And it was rejected on dated 22/11/2019, your lordship. Thereafter, another IA was filed.
Just a minute, let us see one by one.
My lord.
First application rejected 2019 para kହୁଛନ୍ତି.
My lord.
No, that was the application filed by only appellant number 3.
That was rejected.
ଆମେ ଆପଣଙ୍କୁ କଣ ପଚାରିଲୁ
My lord.
ଆପେଲାଣ୍ଟ ନମ୍ବର 1 ଆଉ 2 ର ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି କି ବେଲ୍ ଆପ୍ଲିକେସନ?
ନାଇଁ ସାର୍ ତାପରେ ଆଉ ଥରେ ଗୋଟେ ଅର୍ଡର ହେଇଛି 18/8/2016 ରେ that was also rejected for non proceedings.
11/7/2014
reject.
ସେଥିରେ ରିଜେକ୍ଟ ହେଇଥିଲା।
ତାପରେ ଆମେ ଏଙ୍ଗେଜ ହେଇଛୁ ଆଜି
ଠିକ है
ଜାଣିପାର
ଏଇଟା 1, 2 and 3 rejected. 4 ଆଉ 5 ନା allow ହେଇଛି।
जो ଆପଣଙ୍କର 11/7/2014 ରେ
my lord.
ଏଇ ଯୋଉ ଦି ଜଣଙ୍କର ପାଇଁ ଆପଣ ବେଲ୍ ଫାଇଲ କରିଛନ୍ତି ଆପେଲାଣ୍ଟ ନମ୍ବର 1 and 2 ଙ୍କର ରିଜେକ୍ଟ ହେଇଥିଲା।
My lord.
ତାପରେ ଆଉ ସେମାନେ ବେଲ୍ ଯାଇନାହାନ୍ତି।
My lord.
So since when you are in custody?
My lord. All the appellants are arrested on the 24/3/2011 year lords. Date of arrest 24/3/2011.
ऐसी प्रथम इंटरिम बेल तापर बोधे 2021 पूरा बेल दिया गला बाय ऑर्डर डेटेड 10/8/2020
Judgment are
mainly on the ground with the sentence from the in the meantime 10 years of the law. So what is the offense for which you have been found guilty and what is the sentence imposed?
My lord, we found guilty under section 302/34 of IPC, your lordship. Only basing upon the statement adduced by the opposite pleadant number 3, your lordship.
Yeah, PW3.
3. They get the port, child witness.
He is an eyewitness to the occurrence.
Eyewitness to the occurrence.
What is the name of the deceased?
One. Sorry. One Alphas Munda. Sorry, this is Alphas Munda. And number 2, this is Fulria.
It's a case of double murder.
Double murder.
What is the name? What tell me once again?
One first, the husband of the deceased, number 2, is Alphas Munda.
Alphas Munda. Then
the lady deceased, Fulria Munda.
They are the husband and wife.
Oh, both.
So this eyewitness PW3 is their son.
Son, your lord.
So let us see the evidence of PW3.
My lord. He specifically stated, your lordship, in para 3, your lordship. He know the accused persons standing in the door. Deceased person are my parents. 1 year back, the incident took place in the night hour. At the time of incident, we are sleeping in our house after taking dinner. The accused person came to our house and knocked the door, for which my father came and opened the door. Then accused Harun and Nobino, 1 and 2 year lordship petitioners, assaulted my father of his head by means of an axe. Tangia accused Harun particularly assaulted my father by axe, and accused Nobino assaulted my father by fist blows. When my mother was objecting to the section, accused persons origin petition number 3, your lordship, Gaino fully accused Argan assaulted my mother by axe on different parts on her head, others by hands. I went away to my grandmother's and informed the matter to her. Then myself and my grandmother went to the informant Bhikkhu. I went away from the spot out of fear. Cross-examination, your lordship. Specifically stated, he was at the time of It was a dark night, your lordship. But it was discarded by the trial court, your lordship. But he has not specifically stated who assaulted what your lordship. Simply stated by tutoring that the petition number 1 was assaulted by means of X.
With the doctor
Dr.
conducted
Malik.
PM.
There is two doctor, your lordship. My lord, here.
Below 11, don't have.
PW11.
Here, your lordship.
13 minutes.
PW11 is one doctor.
One doctor.
Another 13.
And 13 is the
13.
next doctor who conducted the autopsy. Specifically, the offense 11, petition number 11, your lordship stated the open of offense was not sealed by the IO. It will produce in open condition for my examination.
Specific matters you have to argue at this time of final hearing.
And PW8, my lord, is a extrajudicial confession.
Yes, yes. I will, if court ask, I will clarify.
So detention period, Mr. Das,
My lord.
it is for more than 13 years.
More than
That date is correct. What he is telling that
That's my lord.
24/3/2011.
That is
Harun,
not-
yes, sir. That is actually it is 25 forward hell. 25/3/2011 Nabin Nabi say same date. 25 and they were not released on bail during trial.
my lord. They were
The
releasing that.
convicts are produced in court.
Why for the difficult something? Why pick it?
Assaulted my father by arts. Then
The other issues by fist blows.
Nabin assaulted my father by fist blows. When my mother, objecting to the action, accused person also assaulted my mother. Argues one so. So, Nabin with a general allegation, but are the Learning Council for the this is an application for bail filed by appellant number 1. Appeal में मुताबिक Harun Tirki and appellant number 2 Naveen Tirki. The Learning Council for the petitioner submitted that both the petitioners are in judicial custody since 25/3/2011, and as such, they have completed more than 13 years in judicial custody. Their earlier bail application was rejected on merit on 11/7/2014. And in the meantime, appellant number 3, Organ Turkey, have been released on bail by this court. No. 25/3/2000. By order dated 10/8/2021. The Land Council further submits the PW3 evidence person that it's a case of double murder of Alphas Munda and his wife Fularia Munda. And the eyewitness is their son Kalrus Munda, which is child witness. And since similarly situated co-accused has been granted bail, the bail application of the petitioners may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail, placed the evidence of PW3, which indicates that appellant number 1, Harun, dealt blow by means of axe on Alphas Munda, who is the father of PW3. However, so far as appellant number 2, Nabin Munda, is concerned, PW3 stated that he dealt fist blows to his father. So far as the deceased Fularia Munda is concerned, PW3 stated that appellant that other appellants कर दिया है ना, that is Argen, Ainu, Fauli, and assaulted him. Assaulted her. And Argen assaulted Fularia Munda by means of an axe on different parts of the body, while others assaulted by hands. The Learned Council for the state also placed the evidence of 2 doctors, that is PW11 and PW13, who conducted post-mortem examination over the dead body of the deceased persons. Learned Council for the state further submitted that PW8 has stated about the extrajudicial confession. कहा की extrajudicial confession करा?
PW8 your lordship.
माने की समझते कले?
हाँ, ये बहुत
By
accused persons,
by both the
accused persons.
by the accused persons.
Whether it is judicial or not.
Considering the submission made by the Learned Council for the respective parties, the nature of overtact attributed against appellant number 2, Nabin, कौन था ना, नवीन मुंडा ना,
Navin Tirki.
Nabin Tirki, that he dealt outside of PW13, that he assaulted the deceased Alphas Munda by fist blows, and for the taking into account his period of detention, more than 13 years in judicial custody, we are inclined to release him on bail. So far as appellant number 1, Harun Tirki, is concerned, since specific overtact has been attributed against him relating to the assault on the deceased Alphas Munda by an axe, and for the taking into account the evidence of the doctor bracket PW13 who has noticed number of injuries on the person of the deceased Alphas Munda while not inclining to opine the cause of death due to hemorrhagic shock, while not inclining to release the appellant number 1 on bail on merit, but taking into account his period of detention in judicial custody and keeping in view the ratio laid down by the court in case of Letty versus so and so. We are inclined to release appellant number 1 on interim bail for a period of 3 months. A report to be called for about his conduct and he shall not indulge in any criminal activities, violation of any terms and conditions, or entail cancellation of bail.
For a period of 3 months.
Appellant number 1 is for 3 months, right? And this appellant number 2 bail granted. What is this later which has come?
For engagement. Engagement engage kariya pai.
Kahaku engage kariya pai?
Srikandanath and myself.
You are Shrikant Kumar?
No, I'm Nilabat.
Okay. That's all right. Next.
Mine.
Item 8.
May it please your lordship.
PW3 evidence लिखिए गुलबर्ग के नौ.
Lordship had called for a report.
कौन आसिला की रिपोर्ट?
Right.
What is the total period you have remained in custody?
More than 12 years.
अच्छा. आगुरु तो कहते जे 2 वर्ष रही ट्रायल बेले.
आज्ञा.
तापरे आपण
Occurrence took place on 10/12/2000.
you made a submission.
My lord, more than 12 years he is in custody.
Then after 2014,
My lord,
if we calculate, then it comes to almost 10 years.
9 years, 10 months.
10 years.
And
your judgment उता देहरु आपण
आज्ञा,
जाइचंती
आज्ञा.
2 मास पाखा
2
पाखी
मास
4
थरे
मास.
छाड़िले 8 सप्ताह थरे छाड़िले.
हाँ त माने 4 मास आपण गले हो.
आज्ञा.
तो 4 मास कटि गले आउ रहिला आपणकर 9 years some odd. So
10 months.
more than 11 years.
My lord.
It's a case of 302.
302, section 9 of explosive substance act.
So that is that Lord
Lord
Soter.
Soter.
IA number 114 of 2024. This is an application for bail. On 13/5/2024, and the matter was taken off, and a submission was made by the Mr. B. Pujari, Land Counsel, appearing for the appellant, Dhodi Sahu alias Pramod Sahu, that the appellant had remained in judicial custody for 2 years during pendency of the trial, and after pronouncement of judgment on 23/7/2014, he was taken into judicial custody, and he was granted interim bail twice by this court. Once for the first time as per order dated 18/11/2022 for a period of 8 weeks, and second time as for a period of 2 months as per order dated 11/10/2023, and he surrendered after availing the interim bail at right time. We asked the learned counsel for the state to obtain instruction as to whether there is any allegation of misutilization of liberty by the petitioner while on interim bail, and whether there is any criminal antecedent against the petitioner. Today, the learned counsel for the state, Sapparagallati, has produced the written instruction dated 15/5/2024 received from IIC Purighat Police Station, Cuttack, UPD, wherein it is indicated that the criminal antecedent aspect of the petitioner was verified from the available PS case record, and it was found that he is not involved in any other case except this case. And during the interim bail period, nothing adverse was found against him. Considering the submission made by the learned counsel for the petitioner that the petitioner has remained in judicial custody for more than 11 years during trial as well as during pendency of the appeal. And since there is no chance of early hearing of the criminal appeal in the near future, and there is no allegation of misutilization of liberty, we are inclined to grant interim bail for a period of 3 months to the petitioner. While on interim bail, the petitioner shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Yes, next one is
Connecting case, my lord. He was on interim bail for 5 times, my lord, and surrendered at the right time. The lordship has also indicated the same by virtue of order dated 13/5/2024.
okay. Any report you have received, Mr.
Not for in dispute.
Let the learned counsel for the state obtain instruction as to whether there is any allegation of সেই order একা order তো পাস
Same order.
Again, এটা
কোন থানার আসে
এটা same
Purighat police station.
এটা হচ্ছে
5 times was released on interim bail and
Let it tomorrow, my lord, I will take instruction.
surrender at right time.
কালি পুরিঘাট থানা তো দেখে
It is there in the weekly list. It will be
Yeah,
taken
okay.
up. Yes.
Item 9.
Please use the mic properly.
My pleasure, Lords. My lord, matter was listed on Friday.
Your name is not there, Mr. Jafrullah. Second. Oh,
Phone ask you
second item.
second item ताले so जो kidnapping case टा निकले 50 लाख demand करते ले
Wait. Just
custody for
that is Siddheshwar Jani.
जानी आई
An opinion learned counsel of an instrument regarding criminal antecedent if any. कौन आनिले की instruction? Let's say this is item number 9, second item. 9 CRLA 132 of 132 madam. About the criminal
Right.
antecedent. What is the date of custody?
At 22nd February 2013.
2015.
2013.
13.
The date of occurrence was apprehended.
So you have been convicted under section?
Convicted under section 364A by 34 IPC.
364A.
A by 34 IPC.
34 IPC. What sentence has been imposed?
Life imprisonment.
Life imprisonment.
And I know
What is the allegation against you?
Allegation against him that victims stated that two persons came by covering their face and say while he was going to tuition along with Malat PW5, they were taken to a forest. Thereafter, so many villagers came and informant also came to know. Thereafter, police also came, and that another accused, it is alleged when all persons came, he put a knife in the neck of the victim, and and thereafter he was caught by the person and is apprehended by both the accused persons were apprehended.
What is the name of the victim?
Jitendra Sahu.
Jitendra
Sahu. And
is PW?
PW7.
PW7.
Yeah, he along with Malat, both he and PW3, they went to for tuition.
PW3 and PW7.
PW3 Malat, he did not state Malat, he stated that I do not know the accused person standing in the dock.
Acha, so he not identified.
Malat.
7 identified.
7 his victim. And the fact remains Malat, the matter also from IO has also stated that there was a piece of government forest land.
Wait. Producing I was proceeding to attend my tuition class.
So for the demand is concerned,
when two persons, both of them had covered their face by cloth, jewelry respectively. Both the culprits came to me, the accused Siddheshwar Patel of so-and-so. They dragged me the forest. Devendra went to call others and I started threatening me. Both the culprits pelted stone and towards the person on fear of so-and-so. The culprits collected phone number of my father. Phone number. Rupees 50 lakh. We are asking you that his father is a cultivator. So
yeah. So he's a cultivator, PW1. And also evidence come they occupied a land, piece of forest land, which was the dispute mallet. And so IU also stated so. I have stated that it is a fact that there is a dispute between informant and other and the accused persons related.
You have remained in custody for more than 11 years.
My lord.
You have never been released on interim bail.
No, my lord. My first bail application is also 2017. I preferred bail appeal, my lord, belatedly.
All right.
abrasions, all are abrasions. There is a simple nature might have been caused by harm. Or the learning council for the this is CRLA number 132 of 2017, item number 9. है ना? This case number 352 of 2017. The learning counsel for the petitioner submitted that the petitioner is in judicial custody since 22 to 2013, and as such he has remained in custody for more than 11 years. The learned counsel submitted that PW3, who is stated to have accompanied the victim PW7, has not identified the accused persons in court. So far as PW7 is concerned, he is a child witness and he was rescued on the very day of occurrence, and the doctor bracket PW13 who examined him noticed some abrasions on her body which have been on his body which have been opined to be simple in nature and could have been caused by hard and blunt object. The learned counsel further submits that there is no chance of early hearing of the case and balance of convenience is in his favor. Therefore, the bail application may be favorably considered. The learned counsel for the state, as per the order dated 17/5/2024, has produced written instruction received from officer in charge, Sadar Police Station, Bhavani Patna, dated 19/5/2024, wherein it is mentioned that the petitioner, there is nothing adverse found against the petitioner except this case on verification of the available PS record and CCTNS portal. The written instruction is taken on record. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced, the period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed. Stay realization of fine.
Item 10.
May it please, Your Lordship. Your Lordship, the present appellant is in custody 9/11/2011.
You have filed this bail application for
Karunakar Malik.
one.
Yes, Your Lordship. Only for
Karunakar
appellant.
Malik, right? And State Council on that day submitted that he has not submitted, received the deposition copy. Now the deposition copy are available. Okay. What is the conviction and what sentence has been imposed on this appellant number 1? 30234. Life.
Along with
No.
498 to 304.
498 ଅଛି?
Again. 498A,
3004.
4B.
Just a minute. 498A, 304B, 302 by 34 IPC and 4 DP Act. So how this present appellant is related to the deceased?
Lordship, the present appellant is the husband of the deceased.
Husband. Achha. What is the name of the deceased?
Name of the deceased is Hemalata Malik.
Okay, when their marriage was solemnized?
2011.
2000.
2011 marriage. And occurrence date?
2012.
2012. So, what is the cause of death as per the PMD? Born injury. Any dying declaration?
PW10.
PW10 DD. Working as orthopedic specialist during evening round, I attended the patient. हेमलता मलिक अच्छा केबे ये हला केबे डेथ केबे हला के दिन परे
Your Lordship, the year of marriage is 2010, Your Lordship, and the date of occurrence is 25/10/2011, Your Lordship.
25/10/2011.
11. Yes, Your Lordship.
When the death took place?
The death took place on the very same day, Your Lordship.
Same day, okay. During the evening, I attended the patient Hemlata Malik, wife of so-and-so, 100% born injuries. Husband poured kerosene on.
Your Lordship may look into the cross-examination of PW10, Your Lordship.
Cross-examination of?
PW10, Your Lordship. That very attending doctor, Your Lordship. The dying declaration are recorded as questions and answers. As the patient was serious and was unable to talk, I only wrote the above statement.
Okay, just a minute. Then what is that relevant question? It's like leading question. So
Yes, Your Lordship. That is not been recorded in a question answer form.
Is not is your duty being a doctor to record the dying patient under your treatment going to die? The duty is on. Why you did not record in so for you? There was no written permission to record. Acha. Is it a dying declaration? It is not a dying declaration, because the condition of the patient was serious and low condition. I recorded this type of statement. This type of statement on a form. And as per the statement, her husband poured kerosene. Exhibit 4 होची report. Exhibit 4 टाइप बात है. Exhibit 5 ता पूर्वटा. Oh, it has a better ticket.
Inquest.
Alleged case of normal born injury identified by so-and-so. Oh, अच्छा था पूर्व case. Exhibit 48. As per the statement of the deceased, her husband poured kerosene oil over her and so on so. But again, that statement, the dying declaration are being recorded as question. The patient was serious and unable to. I only wrote the above statement. The person. So, who was accompanying him at that time to the?
Your Lordship, PW10 has himself stated that he has recorded this statement as per the version of people of the patient.
Where is it?
That is in last para of the cross-examination.
As per the version of people of the patient, I made the above info. Acha. Oh. That means, Mr. How can it be a dying declaration of the deceased? This last line, have you seen that? As per the version of the people of the patient, I made the above endorsement. So who are those people who accompanied her to the hospital? Have they stated that the deceased made any such statement while being taken to the hospital?
Lordship, PW5.
Who is that?
Your Lordship, the mother of the victim had accompanied the deceased to the
Who is,
hospital. That
who is she?
is PW5, Your Lordship.
PW5 is the mother, PW6 is the father. PW5 कहले, I know Karunakar Malik and now I also know the accused person so and so. My daughter had married Karunakar 2 to 2.5 years. Pitambar Malik is the father-in-law of the so and so is the so and so. Examination in chief is deferred. My husband telephoned me from Cuttack intimating about the एक अरे से दुई पेज कोड़ा लगी हाँ एक पर कौन चारि कौन पेज पड़े तीन पर इस पेज नंबर 2 give it the original এটা ঠিক করি ইনসার্ট করি বাচ্চারা PW5 ର ଦିଅ statement
Your Lordship, the other witnesses are PW6 and
yeah,
PW15.
just a minute PW5 you said accompanied, let us see that husband informed PPW5 the husband informed the PW6 informed the PW5 over telephone regarding the death of the deceased from Cuttack. That is in para mallet 5 page 4 first line. My husband telephoned me. Just want to know whether well, can we come to PW7? But there are two chronological points. PW7. PW7, man. Yes. On 25/10/2011 at about 4:50 p.m., I was working as the dresser in the Bon ward of so-and-so Jaspur. On that day, a patient aged about so-and-so injured was admitted in bed number 68 of our ward in DHA Jaspur, to whom I cannot name now. Mr. Dilip Kumar Janna, the orthopedic specialist during being in charge of the surgery, specialist was treating the lady patient. I saw the doctor recording the dying declaration of the injured in the bed ticket and remaining present near the injured. And the doctor, I heard from her that her husband, Karunakar Malik, put kerosene oil on her and set fire on her, and she gave her above statement on being asked by the doctor. by doctor. Doctor himself.
Himself. That's my. That's I'm. And the contradiction.
কারণ ডক্টর কইছে as per the version of people of the patient
In the
and made the above endorsement.
Who are they?
Who are they?
And
Whether they
because the parents are also not present.
ନାଇଁ ସେ ମା ତ କହୁନି ମୁଁ ଯାଇଥିଲି
ହଁ ବାପା ଇନଫର୍ମ କଲା ବାପା ପହଞ୍ଚିଲା ବେଳକୁ କହୁଛି already declare.
Your Lordship, may look into the cross-examination of the very same PW, Your Lordship, PW7.
PW7.
Yes, Your Lordship.
Yes.
I do not know the date of my examination by the police. I had seen burn injuries at the hand, 2 places on the chest and face of the husband of the deceased. Both the wife and husband were being treated simultaneously at District Headquarter Hospital, Jajpur. Thereafter, she says the mother and another lady were there near the deceased.
You are reading whose evidence?
Your Lordship, PW7, Your Lordship. Paragraph number 3, Your Lordship.
Paragraph 3.
Yes, Your Lordship.
Paragraph 3, I cannot.
I don't know the date.
Yeah, Goriji. Huh? PW7. No, PW7.
What is the name of the witness? PW7. Original
PW
name Arjuna Char Malik.
So
Para 3 cross examination begins with it is not a fact that. No, para 3 is I don't know.
The page number 2 টা তা পূর্বর রয়ে যাই এইটা দেখি না 270 এই কি আপনি করছেন ওটা পেজ কি স্ক্যানিং করছে আর চেক কি করছে খবর দিয়ে দাও seven. Sufficient products.
Your Lordship, para 3. First para of the cross examination.
Paragraph 3 start is I do not know the date of my examination.
Yes, Your Lordship.
I had seen the burn injury at the hand, 2 places on the chest and face of the husband of so and so.
Husband.
Wife and husband were being treated simultaneously at district hospital. I treated for 20 minutes to the wife and thereafter I started treating the husband, bed number 1, the mother, and another lady were there near the deceased. I had not marked the father of the relation of the mother of the deceased were there or not. It's not a fact that I'm being told. Deceased had received severe burn injuries. Pulse was slow and congested. Doctor asked if she herself would body or anybody else her body said by the report saying that her husband was an and said that Dr. myself was a staff. Staff cannot see. দরকার ছিল ক্রস এক্সামিনেশনে পৌঁছে
Fiddle 7 cross section भी से कही जे ता voice slow थला मैं recording है जे so he has stated in para 4 में
ये चीफ रे खाली एती कहला
Fiddle 7 रा para 4 में doctor रा
doctor is something different.
different. What is the exit 4 malor? Can my lord has gone through the exit 4 malor?
ये खाली लिखा है जी ता हाथ से डॉक्टर निजे लिख दे छी ये कहला एग्जिबिट जे चलो डॉक्टर एग्जिबिट 4 टा बाहर करो जोटा बाहर करथिलो हां सेटा दे हम बस as per the see what side रे एमती लिख दी जंदे as per the statement of the deceased her husband poured kerosene oil over her
As per the statement of the deceased.
हाँ से लिखा है as per
हाँ।
the statement of the deceased ताकू प्रश्न पचरा गला जे आपण ए जोटा लिखिले एटा तो क्वेश्चन आंसर जोटा चीफ
हाँ।
एग्जामिनेशन बार
पचाला
तापर सी से टू लास्ट क्रॉस एग्जामिनेशन में कहूची जे
The
मु एटा
version of the
लिखिदेली
people
हाँ
of
as
person
per the version of the people of the patient I made the above endorsement
above
ता माने
endorsement.
सेटा ई जोटा जदी हमें simultaneously read करिवा then whatever he has written in exhibit 4 that was not the version of the deceased but it was of the version of the people who accompanied the deceased.
But यदि सेटा को हमें देखिए Fiddle 7 ର statement को नबा एवं first para of the Fiddle 1 10 my lord जे Fiddle 7 को जी this is on being asked by the
No,
doctor.
no, we will not enter into the
Madam.
detail because we are not hearing the appeal.
Madam.
First of all, he has remained in custody for almost 12 years and
6 months.
Madam.
Whether
What
this,
about the sister-in-law? She is on bail.
Your Lordship, all the other appellants are on bail. Your Lordship.
The specific allegation against the sister.
are the learned counsel for the petitioner, Bini Mishra through virtual learned counsel for the state, learned counsel for the petitioner submitted that the petitioner, Karunakar Malik, is the husband of the deceased Hemalata Malik. And their marriage was solemnized in the year 2010. The occurrence in question took place on 25/10/2011. And it's a case of death by burn injuries. And the main evidence available against the petitioner is the dying declaration stated to have been recorded by the doctor PW10, bracketed PW10. She argued that even though the doctor stated in his examination in chief that he noticed 100% burn injuries on the body of the deceased, and as per the statement, the petitioner, bracket and I comma, her husband bracketed the petitioner Khaliba, the Durkan, poured kerosene over her under the influence of alcohol, and accordingly she mentioned the same in his report exhibit 4. But in the cross-examination, he has stated that as per the version of the people of the patient, he made the above endorsement. According to the Land Council, the dying declaration cannot be accepted in the eye of law, and there are good chances of success in the case, and balance of convenience is in his favor. And the appeal is also not ready for hearing, and therefore the bail application may be favorably considered. Land and Council for the state submitted that not only the Dr. PW10, but also the treasurer in the born ward of DHS Jashpur, who has been examined as PW7, has also stated about the deceased making dying declaration before PW10, implicating the petitioner who have poured kerosene on her body. The Land Council for the state also placed the evidence of the and absence of any chance of early hearing, keeping in view the ratio laid down by this court in the case of Leti versus Strauss, one associate reference University. We are inclined to release him on interim bail for a period of 3 months. Shall not indulge in any criminal activities, and State Council shall maintain report of the concerned IAC about conduct of the petition. Yes.
Much obliged, Your Lordship.
The honor person.
Item 11.
I'll 11 I just now served the deposition copy. Let the matter come tomorrow, my lord.
We can go through it
Tomorrow, my lord. Also, I filed the chat and notes of admission. I'll file those.
Item 12.
Well, Yatindra Mohan Rao.
Transformer. Judgment copy ଗୁଡା ବି detach କରୁନାହାନ୍ତି। ଆପଣ ଦେଇଦିଅନ୍ତୁ pen drive ରେ ଦେଇଦିଅନ୍ତୁ। Judgment copy ଆଉ equation copy ସୁଦ୍ଧା ନେଇ
Item 13.
same form.
Item 14.
IA for bail, man. Convicted under section 302.
There are two after that.
Mine. I'm for now for appellant number 1. Appellant number 2 is on bail.
28/7/2016 ରେ reject ହେଇଥିଲା ଥରେ। 28/7/2016 one ର
1 ର 2 ର allow ହେଇଥିଲା 1 ର reject ହେଇଥିଲା।
What is the date of custody?
Custody was 16/6/2012.
That means you are not on
No,
bail.
no.
Extension of which you are found guilty.
302 man. 302/33
Life imprisonment.
miles.
What is the name of the deceased?
ଟଙ୍କଧର ନାଇଁ।
ଦି ଜଣ ବୋଧେ କୈଳାସ ମାଝୀ।
କୈଳାସ ମାଝୀ one of the injured.
Okay. Deceased.
Deceased.
Deceased, right?
Kailash Majhi is one of the injured.
Date of occurrence?
Date of occurrence 10/6/12.
10/6/12.
Man.
Who is that injured?
Injured is Kailash Majhi, who is PW 16 man. Man.
And PM doctor is?
PM doctor is PW 7.
And who examined the injured Kailash?
That injury requisition has not, injury report has not obtained by the IO of Kailash Majhi.
Let us see what the Kailash is.
Man.
The accused person threatened to Dr. for that. Assuming was the accused person came from behind. Immediately assaulted the deceased by means of
Photobahi. And one stick was also recovered.
Investigation is against
Both the accused.
Then why the one was granted bail, the other bail?
He was not on bail duty.
That is the reason.
Yes.
And what is the, let us see the doctor's evidence,
PW7.
Lacerated wound on the right eyelid, lacerated wound on the fracture of leg, hospital vision, left parietal fracture of all the leg was the rectangular hemorrhage and the strong condition. So
Hello.
he looked into the evidence of this weakness, PW16 and injured. It indicates that both the appellants are
Same person.
same.
stated that bail application was rejected. It was granted because he was on bail on
trial.
during trial. So let us see that all of us. 27.
28/7/16.
Response is concerned, he was on bail during trial. He has received the are the current counts for the decision application for 5 current Sava. The 11 count petition of speaking.
11/6/2012. 11/6/2012.
And so the last month that was interview 16 in his evidence being accepted as PwC. In his evidence was stated that all the apparents came from behind and assaulted the deceased by means of the all the bracket from October and Hon'Ble on head. It's further submitted that the apparent number first suffer start from the similar booking has been released on bail as per the forum dated 28/7/2016 by this court by rejecting the bail application of the present petition, mainly on the ground that he was on bail during trial. He has not utilized the current counsel for the submitted that the case is not waiting for hearing because it has not been prepared. And therefore the bail application favorably considered. Current counsel for the state while not disputing that as for the evidence of PW16 what act activity against the appellants are similar. Place the evidence of the doctor bracket PW7 conducted post-mortem examination. Fine for the during the submission of the period of detention of the patient, which are absence of chance of early feeling that they are inclined these petition.
Fine may be stated.
There is no instant application to that effect.
1077 of 2015.
IA number
1077 of 2015. Fine was stayed in favor of Suraj Savar on that day. Fine was stayed in favor of appellant to Suraj Savar on that day.
But that is not being disposed of. That miscase is still pending. That miscase you have also prayed for
My lord, fine of both the, my,
This case number 1077 of 2015. That there has been history of violation of others. Constitution. I ask the whole
okay.
Item 15.
In Mr. Niranjan Pradhan.
My lord. Okay, my lord, I am appearing for the 3 appellants in this case, my lord. I am appearing for 1. My lord, and playing for bail for 3 appellants, my lord.
There are number of criminal.
In CRL number 218 of 17.
ପ୍ରଥମଟା ହଉଛି 220 of 2017 ଏଟା ପାଇଁ କି appeal କରୁଛନ୍ତି ଡମ୍ବରୁ ମାଛ
I am appearing for Nomurumach.
one by one.
My lord. My lord, entire they are languishing in custody for more than 12 years. Sir. CRL 218 2017 220 2017
ଟିକେ ରୁହନ୍ତୁ ଆପଣଙ୍କର ଗୋଟେ ଗୋଟେ କହିଲି ପରା
ଆଜ୍ଞା
ପ୍ରଥମେ
sir
ଆମେ ନଉଛୁ 220 of 2017
220 2017 sir ମୁଁ appear କରିଛି 220 2017 I am appearing in this case for Dombu Maji.
business petition of the apparent paying for engagement of so and so acha ଆପଣଙ୍କ ନାଁରେ petition ଆସିଛି ଆଚ୍ଛା ଠିକ ଅଛି ଆପଣ କୁହନ୍ତୁ so ଲେଖି ନେବୁ CRL number 20 of 2017 period business petition wherein prayer has been made for engagement of Vijayalakshmi Tripathi in case of Niranjan Panda. Mr. Tripathi has already filed now. The name of Niranjan Panda, the name of P.L. Tripathi and her associates be reflected in this court. Yes, now we can ask Mr. Tripathi, what is your permission?
And other 2 appeals also.
Should କୁହନ୍ତୁ ଡମ୍ବରୁ ମାଝୀ ବିଷୟରେ କହିବେ ନା ନାହିଁ?
Yes, my lord. I am appearing on IA for bail, my lord.
My lord, the period of detention.
Is in custody since 13 to 2014, my lord. Since the date of arrest is in custody.
This appeal has been filed by only a child.
13/2/14.
And what is the conviction and what is the sentence?
Sentence life sentence, my lord. Convicted under section 302 and 34, my lord.
What is the name of the deceased?
Sadananda Bibhor. One deceased, my lord. Bibhor. Sadananda Bibhor.
BIBHAR.
Yes.
Bibhor.
Bibhor.
BIBHAR.
What is the date of occurrence?
11/2/2014 at about 7 p.m. my lord.
Eyewitnesses are there.
PW2,
Yes,
my
sir.
lord.
PW2. Wife of the deceased.
And who is the doctor who
PW11.
PW11, my lord.
Land Council further submits that paper book is ready, but there is no chance of early hearing of the appeal, and balance of convenience is in favor of the petitioner, and therefore the bail application may be favorably considered. Learning Council for the state, on the other hand, opposed the prayer for bail, placed the evidence of PW2. So also the evidence of Dr. PW11, who conducted post-mortem examination over the dead body of the deceased, noticed number of injuries on different parts of the body and opined that the cause of death was due to craniocerebral injuries and its complications. Considering the submission made by the London Council for the respective parties, the nature of evidence due, the background of the case, the period of detention in judicial custody, absence of any chance of early hearing. And the surrounding circumstances under which the occurrence stated to have taken place. We are inclined to release the petitioner on bail and shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Bail allowed.
My lord, criminal appeal 218 2017 और 221 2017. I am appearing in this case.
My lord, I am appealing for 197 and
ठीक है
270.
Yes.
Norimaji and Dalimaji.
218 टा आपणकर
218 रे धनपुल माझी.
Same date.
Same date of occurrence out of one.
Date of
221 रे डम्बू माझी.
just a minute. Single appellant सबुथरे.
Yes, my lord. One
so CRLA number 218 of 2017
धनपुल माझी.
bail allowed. ହେଲା ଆଉ ଗୋଟେ କୋଉଟା ଆପଣଙ୍କର
ଆଉ ଗୋଟେ 221 ରେ ଡମ୍ବାବୁ माझी.
ଆଚ୍ଛା same bail allowed.
Same date of occurrence.
hard date
my
of occurrence समान ଏଟା ଲେଖିବେ hard
डॉली माझी लबो माझी
विजय लक्ष्मी त्रिपाठी ହେଲା PL त्रिपाठी କରିବେ ହଁ
197.
ଆପଣଙ୍କର ହେଲା 197
97 and 270. Nori Maji and Dolly Maji.
Let us go one by one.
Sir.
197 there is no bail application. Have you filed any bail application? (513) granting bail. I first want to receipt of the bail application. 513. अगर अच्छी पेंडिंग अच्छी से केस टा 513 टा no it has been disposed of by the order dated 16/1/23. Mr. Panda, London Counsel for the appellant, instead of pressing the application for bail for grant of bail, prays for hearing of this appeal. So this case is disposed of. There is no bail application now. Yes, and what about CRLA number? Out of quota 217. Same order. This is the
218
218 bail allow hela
218 220 221 তিনটারে bail application ଅଛି
allow hela to phuni kon
sir ନା ବେଲ୍ ଆପ୍ଲିକେସନ ଆଇଏ ନମ୍ବର ଗୋଟେ
हाँ ये अच्छी तो
ଆଜ୍ଞା,
लिस्ट अच्छी जो थे
ଆଜ୍ଞା।
नहीं हम पहुंचे यहाँ 219 219 there is no bail application. Let us see that. Wait 577. Please wait. 577. Yes, this is an application for bail, but just back. 577 of 2017. On 16/1/2013, it has been mentioned like this: Mr. Rayaguru, learned counsel for the appellant, instead of pressing this application for grant of bail, praised for hearing of the affair on merit, disposed of. What happened, we do not know. IA has already been disposed of, right? So if you want to file any bail application, you can
No.
file. There is no liberty.
Sir, all these matter, there was a common hearing. So instead of pressing the bail,
Mr. Panda,
Sir.
the interim application has already been disposed of.
Sir.
We cannot revive that order and pass.
No, I'll
If you
file another,
intend to file,
afresh.
you file another
Yes,
application.
yes.
To
Sir,
prevent
oblige,
you.
sir.
All right, next.
Item 16.
The offense under section 302 and a fine of 10,000.
Please wait. How many appellants are there?
Single appellant.
Single appellant. Okay. What is the date of custody?
Is in custody since 27/4/2013, my lord. More than 11 years.
And you are found guilty under section
302.
302, life imprisonment.
Yes, my lord. Fine of 10,000.
What is the name of the deceased?
Name of the deceased, the wife of the petitioner. Name is Koitha.
Koitanaik.
Koitanaik.
Koitha Naik. She is the wife of the petitioner.
Yes, my lord.
And date of occurrence is
25/4/2013.
And what is the cause of death?
Cause of death is asphyxia by strangulation.
Strangulation.
Yes.
Who is the doctor who conducted postmortem examination?
PW10.
Ligature mark horizontally. अच्छा horizontally इसको. So both of you are staying together.
Yes, ma'am.
How many years after marriage this occurrence took place?
That is not his son, is also son and daughter-in-law of the
Witnesses.
Yes, ma'am.
Who are they?
PW6 is the son of the deceased.
PW6 वाला son और
PW7 is the daughter-in-law.
PW7 वाला daughter-in-law.
Both.
Bohu.
Yes, ma'am.
Let us see what they have stated. PW6.
PW6 and 7 are also living separately.
The accused wants, so my mother died. My mother and father residing in our house. I was residing. In the morning, my father told me that he is going to search for his wife, and after thorough search, he did not trace her. Mother hanging inside the house. Achha. So though the dead body was found hanging in your house, but the doctor says that the ligature mark was horizontal. It was not obliquely placed.
Yes.
And to find that it was a cause of death on the account of asphyxia due to strangulation. That means after killing your wife by pressing her neck using ligature, you made every attempt to show that it's a case of suicide by hanging her body from your house, from the ceiling of you. That is the case. And now you have remained in custody for more than 11 years. You are not on bail during trial.
No.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submit that the petitioner is the husband of the deceased Kointho Naik, and he is in judicial custody since 27/4/2000.
28 my lord.
28/4/2013, ठीक तो?
Yes, my lord.
And the evidence of the son and daughter-in-law of the petitioner who have been examined as PW 6 and 7 indicate that the dead body of the deceased was found hanging from in the house of the petitioner. But taking into account the evidence of the doctor, bracketed PW10, who conducted post-mortem examination and opined that the cause of death was asphyxia due to strangulation, the Lenin trial court has convicted the petitioner under section 302 of the Indian Penal Code. It is further argued that there are good chances of success and balance of convenience is in his favor. There is no likelihood of the appeal being taken up for early hearing, as paper book has not been prepared, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, placed the evidence of PW6, PW7, and Dr. PW10. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced during trial, particularly in view of the evidence of the doctor, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention for more than 11 years, we are inclined to release him on interim bail for a period of, and keeping in view the ratio laid down in the case of Letty versus State, we are inclined to release the petitioner on interim bail for a period of 3 months. A report be called for about his conduct from the concerned IAS. Shall not indulge in any criminal activities. Bail allowed for 3 months. Okay.
Item 17.
17 we have taken up after vacation. In the meantime, I will solve the deposition.
Mr. Muyal and counsel submits that the matter may be adjourned after ensuing summer vacation, and in the meantime, will supply the deposition copy to the Land and Council for the state in view of submission put of this matter in the week commencing from 24th June 2024. Okay.
Item 18.
May I please, madam? IA for bail merit. The appellant convicted for RI life.
Yes.
For the
Wait. Single appellant.
yes, madam.
Notice served on yesterday, my lord.
What notice?
Three
SST Act
SCST.
is there, madam.
Oh, SCST.
My lord.
Then we have to give at least 1 week time. We may be interested to engage some other counsel to
Yes,
oppose the application for bail. Won't be possible. IA number so and so, this is an application for bail. The London Council for the State submits that notice on the informant has been served yesterday to the inspector in charge of Doraguda Police Station. In view of such submission, in order to give opportunity to the informant to engage in counsel, propose the application for bail if he so likes, put up this matter in the week commencing from 24th of June 2024. If any London Council files Bhinama for the informant, the same shall be placed on record and the name of the London Council be reflected in the cause list. Yes.
Item 19.
Please, Your Worship, this is a case under section 302, 323 and 34 IPC.
Yes.
I am for the second appellant number 2. My lord,
Just a minute. They're just coming.
Item 19.
My lord has pleased to ask the state to produce the custody certificate along with the criminal records.
I have obtained and sent. As for the custody certificate, my lord, 4 year, 5 months, 3 days till 12/5/2024.
Okay, this is for apparent number 2.
My lord.
Apparent number 2, the submission is that the apparent number 2 has remained in custody for 13 years.
My lord, I pray the deposit copy of PW 926.
My lord, I will upload
Just
the
a minute.
instruction regarding
You are
appellant
moving
number.
this bail application.
This for
Apparent number 2, na?
yes, my lord.
Just a minute. IN number 1007 of 2024. The I get a one. Flag D. This is for Guru Naik.
Yes, my lord.
My lord, kindly this matter will be taken up tomorrow, my lord. I will obtain instruction regarding appellant number 1 by mistake.
ସେ ତ 2 ପାଇଁ ଫାଇଲ କରିଛନ୍ତି 1 ପାଇଁ କଣ ନେବେ?
By mistakenly 1 ro next tomorrow I will obtain instruction regarding
ଆରେ
this one.
1 ନମ୍ବର ପାଇଁ ବେଲ୍ ଆପ୍ଲିକେସନ ଫାଇଲ ହେଇନାହିଁ।
My lord.
ଆପଣ ଯଦି 2 ନମ୍ବର ପାଇଁ ଆଣିଛନ୍ତି ତାହେଲେ ଅସୁବିଧା କଣ ହଉଛି?
ନା ଏଟା 1 ପାଇଁ ପଳେଇ ଆସିଛି। ସଂକୁଳି ନାହାକ ପାଇଁ ପଳେଇ ଆସିଛି।
ସେ ଫାଇଲ କରିଛନ୍ତି 2 ନମ୍ବର ପାଇଁ ଅର୍ଡର ହେଲା 2 ନମ୍ବର ପାଇଁ ଆଣିବାକୁ ଆପଣ ଆଣିବେ 1 ନମ୍ବର ପାଇଁ।
tomorrow morning I will obtain.
I want to place the PW 9 man.
ଆଉ କାଲି ପ୍ଲେସ୍ କରିବେ।
ଆଜ୍ଞା।
2-5-2024. Yes, next.
Item 20.
Mr. Vijay Kumar Mahanti. Yes. Yeah.
Item 21.
20 pass over.
हाँ।
Item 21.
Yes.
May I please, your lordship? My lord, 4 persons, including the appellants, were facing trial under section the life conviction appeal is challenged.
No, first tell us that what is the date of custody.
My lord, custody, my lord, since 18/8/2014, my lord.
Okay, you are found guilty under section.
My lord, I have found guilty under section 364A and 365, my lord.
So 364A it is life imprisonment.
My lord.
365 it is
7 years, my lord. 7 years, my lord. 6 months.
7 years.
My lord.
No, 5 years. 5 years is the guy. 5 years fine 5,000 in default to undergo RI for 6 months under 365. So it's 5 years. All right. So what is the prosecution case? Let us come to that.
My lord, the prosecution story, my lord, not said that the appellant used to work as a servant in the house of the informant, namely Guru Charana Nath, under the district of Kendrapada, my lord.
Appellant used to work in the house.
In the house of the informant, my lord, as the servant.
Then what happened?
My lord, on 29/5/2014, the appellant took the victim to the tuition by motorcycle, and thereafter, my lord, 2 days, the father lodged the affair that the daughter did not return to the home, my lord. My lord, the investigation revealed that the victim was confined in different places like in Berhampur, Koraput, Jaipur, Visakhapatnam, Umarkot. Lastly, from Bhubaneswar, after 2 months, the victim by telephone called her father, and father with the police rescued her unhurt, and the victim also not been medically examined.
No, as it appears from the judgment, The date of occurrence is 29/5/2014.
My lord.
When
So-
she was rescued, that 14 years old girl.
My lord, after 2 months, my lord, she was rescued.
So she has been examined as
Yes.
PW.
My lord, PW 8, my lord.
Let us come to that evidence.
There is also, my lord, 164 statement, my lord.
Wait. Let us see. Four friends of so and so kidnapped me by that car. I tried to raise holla. Accused persons closed my mouth and kerchief all the accused persons so and so to Barampur. Then, okay, Bhubaneswar. Then Pipli. And there is allegation that you harassed her physically, emotionally, and sexually. Tried several times to keep physical relationship with her forcibly. Could not able to do the same due to my protest. And demanded, gave a cash of rupees 3 lakhs so and so. But he had not given me his phone to intimate the same so and so. Okay. Earring was taken away forcibly, sold the same. So, what is your submission, Learned Counsel?
My lord, my respectful submission, my lord, 4 persons, including the appellant, were facing the trial, my lord. My lord, 3 persons have been acquitted in 363, 365, 364A, 368, and read with 34, my lord. My lord, the appellant also has
named, they have not been named nor identified in court by the victim, PW. So 8. So that may be a reason for which they have been acquitted. But so far as
my lord, there are prevaricating statement, my lord. My lord, there are only the entire story circle around 3 statements, my lord. Witness number 1, father. Witness number 2, mother. And witness number 3, the victim, my lord.
who else would state it? ଏକ number ହେଲା father.
Father, my lord.
ସେମାନେ କହିବେ ନା
My
ଝିଅ
lord,
ମୋର
father କହୁଛନ୍ତି while taking the victim to the tuition by his motorcycle. Mother says while taking the victim to the tuition by our motorcycle, where the victim herself stated that while I was taking to the tuition by our motorcycle, but in 164 statement, my lord, victim has stated while I am returning from the tuition by my own cycle, I was kidnapped, my lord.
ସାଇକେଲରେ ଯାଉ କି ମୋଟରସାଇକେଲରେ ସେଟା that's a different matter.
My lord.
But the evidence is that you along with the other accused persons, you took her and kept her confined in different places, and you are the person who tried to keep physical relationship with her, but she protested, for which you could not succeed. And you are insisting him to intimate the family members to give cash of rupees 3 to 5 lakhs. That is the evidence against you. So, who accused persons acquitted, not acquitted, that's a different matter. But so far as you are concerned, specific overdraft is there, and you are in custody for 9 years. You are not released on bail during trial.
No, my lord. My lord, after 2 months, it will 10 years, my lord.
9 years, 10 months now it's running. What about your criminal antecedent?
My lord, nothing, my lord.
Yes, Mr. Katkia, what do you say?
Yes, sir. The victim was rescued on 17/8/2014. 17th August.
17/8.
8.
But moving in very freely with him, sir.
Yes.
In motorcycle, etc. are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 18/8/2014, and as such he has remained in judicial custody for 9 years and 10 months. And the victim left the lawful guardianship. Victim are stated to have been kidnapped on 18/8/2014, and she was rescued on on 29/5/2014. है ना? Stated to have been kidnapped on 29/5/2014 and rescued on 17/8/2014. However, the evidence on record indicates that she was moving with the petitioner different places in motorcycle. The land council further submits that the petitioner was the maid servant in the house of the victim. Victim to bracket exam to PW8. And the paper book has not been prepared, and therefore there is no chance of early hearing. There are good chances of success in the case. Balance of convenience is in favor of the petitioner. Therefore, the bail application may be favorably considered. Land counsel for the state opposed the prayer for bail, placed the evidence of PW1 and PW2, the parents of the victim, so also the victim, bracket PW8. He refused for medical examination.
My lord.
Land counsel for the state further submitted that the victim refused for her medical examination. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced during trial, period of detention in judicial custody, absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner released on bail. Stay realization. Have you filed any application for?
My lord. Yes, my lord.
Where is that?
Conviction.
That
No,
is
my
not
lord.
the.
Application for bail 191.
No, that is bail allowed.
Stay relation.
What is the the other application is not.
Stay of conviction and sentence. Stay of
That is not.
conviction and sentence. 192. My
We
lord.
are not granting any stay of conviction. If IN number so on so 192 of this is an application for stay of conviction in view of the evidence adduced by PW8, we are not inclined to grant any, and since conviction can be stayed only in exceptional cases, we are not inclined to grant stay of conviction, and accordingly IS stamps rejected. The while on bail, the petitioner shall not try to come in contact with the victim or family members, and shall not indulge in any criminal activity. Violation of any terms and conditions shall entail cancellation of bail. Yes.
Item 22.
The prisoner's petition was a flag D.
ମୋର କେସ୍ ପରିଚାଳନା ନିମନ୍ତେ କରିଥିଲି, କିନ୍ତୁ ବର୍ତ୍ତମାନ ମୁଁ ଦୀପକ ରଞ୍ଜନ ମିଶ୍ରଙ୍କୁ ନିଯୁକ୍ତି କରିବାକୁ ଚାହୁଁଛି।
He wants to engage another counsel.
So
My power may be.
Who is Deepak Ranjan Mishra?
His power has already come out.
The produce the prisoner's petition at flag D, wherein request has been made to engage Mr. Deepak Ranjan Mishra as his advocate. Mr. R.K.Pattanaik, Land Counsel for the Land Council submits that in view of such prisoner's petition, his name may not be reflected in the cause list. Accordingly, the name of Mr. Swaroop Pattanaik and his associates shall not be reflected in the cause list. Only the name of Mr. Deepak Ranjan Mishra be reflected in the cause list henceforth. The land counsel for Mr. Mishra is not present. Put up this matter after answering summer vacation. Yes. See, we commencing from 24th June 2024. Yes.
Item 23.
There are also one prisoner's petition is there. So at flag D.
Paying for engagement of Ashutosh Tripathi in place of previously engaged Ashutosh Tripathi actually.
Just put note.
Review the prisoner's petition at flag B, wherein a prayer has been made for engagement of Advocate Ashutosh Tripathi in place of the previously engaged counsel. Mr. Tripathi is not present in court. In view, the prisoner prayer made in the prisoner's petition is accepted. The names of Mr. Suryakant Dwivedi and his associates shall not be reflected in the cause list henceforth. Only the name of Mr. Ashutosh Tripathi be reflected in the cause list. Put up this matter in the week commencing from 24th of June 2024. Admission that a fresh admission burana. Fresh admission on it 24 life imprisonment. Oh, तेज जाएंगे चल ठीक है ना ये admission heading रे कहीं गया मुझे शेयर कर पहुंचे हो पेपर बुक तो ये है ना so it should have been এটা hearing list रे आसी वाला तो এটা যদি आसी admission कौन है ही नहीं on this one so delay condone last one last the previously last one to the yes. Delay condone but admit ର କିଛି order ଅଛି ଦେଖିବେ original ଏଇ ଯୋଉ order sheet list ଲେଖା ହେଇଛି list after 2 weeks for admission ତାପରଠୁ ଆଉ order ଅଛି 18/1/2022 ପରେ ଆଉ କୌଣସି order pass ହେଇଛି नहीं all right hard admit कर देछि put up this matter in due course for hearing no next এটা ବି କଣ 2022 ର এটা ସବୁ পেপর বুক ହେଇଯାଇଛି যেটা ବି admit ହେଇନି same order 15/2/2022 ପରେ order ହେଇଛି same admit and hearing will be taken off in due course so ଏଇଟା ଗୋଟେ ଅଛି business petition at flag C and D କାହାକୁ ସେ engage କରିବାକୁ ଚାହୁଁଛି ମୁଁ ତାଙ୍କ ବଦଳରେ ନୂତନ ଓକିଲ ଭାବେ ସୁଶାନ୍ତ ଦାସଙ୍କ ନାଁ ଅଛନ୍ତି ବାକି Total of flag T to some dash upon new reproduction. They compare you the prisoner's petition at flag C and D, wherein prayer has been made for engagement of Mr. Sushant Das as his advocate, since Mr. Sushant Das and his associates have already filed PNAMA. The name of the earlier engaged counsel, that is Subodh Kumar Mahanti, shall not be reflected in the first discharge. बाकी जोड़ाको ରହିଲା କାଲି ଡାକିବ। एक number ଟା କଣ ହେଲା?
Yes, in that case, I have filed a report at Lord's direction.
Item 1,
of this order be uploaded.
Acha. This copy of this this has been handed over to Mr. Devasys Panaik by the Learning Council. Copy to hand upload है तो काली की just hearing will not come. She will just take up those bare matters in